Good morning.
Morning.
Hello, everybody. Right. Hello, morning, Mandy. Delayed everyone. Right, morning. Great to see so many of you here. We're now back up and running doing our face-to-face seminars. Obviously, we've been doing all the virtual things for a while because of all that COVID word. We won't talk about that. But now, obviously, we're going to be doing lots of these events, getting all back in, networking, face-to-face, which is so much better. So I know it's a hot morning, so thank you very much for taking the time to come here, because I'm sure you'd rather be doing sitting in your garden doing other things. Anyway, for anybody who doesn't know me, my name is Katie Davis. I'm a partner in the employment department at Wilkin Chapman. I'm joined today by Lily, who's recently qualified in the employment department, my fellow colleague and partner, Adam Otley, who works in commercial, and we've got Paul Tofton, who's a partner at Forrester Boyd. Paul can obviously explain a bit more about what he does and a bit more about Forrester Boyd when he talks. However, we have a really close relationship with Forrester Boyd. You know, if you come to us with any issues and, you know, it's more of a Paul thing, we will refer that to Paul and vice versa. So it's a bit like a one-stop shop, you know. Come to us with your business needs and hopefully one of us will be able to deal with it, whoever the expert is. And we've got a really good working relationship. So today is the first of a series of seminars which are about, you know, health checking, proof checking, making your business as protected as possible. Okay, we're going through this really weird time. No one knows what's going on with the cost of living. It's all really scary. So what we want to do is make our businesses as protected going forward as possible. We're going to start today's event talking about the appointment, setting it all up, getting it all on the straight and narrow at the beginning, if you can. And then we're going to build up during the series to the climax, which is the nuclear aftermath. Now, it sounds really scary. Hopefully, if you take our advice, we'll only have a shimmering flame and not a big bomb. So we'll protect you and we'll hopefully stop those issues happening. However, issues sometimes happen, you know, especially in employment, but commercial, all sorts of things arise. But hopefully, if you take our advice, we'll get you out of it as quickly and as swiftly as possible. Okay? So you've all got a copy of today's slides. There's a little space there you can write in, swiggle away as you will, or just listen, whatever you think's best. I'm going to be going first, and then we've sandwiched Paul in between. It's like a Forrester Boyd, Wilkin Chapman sandwich. And then Adam's at the end. Lily's got a bad voice, so she's going to be doing a little bit. She's got a bad throat at the moment, so if she suddenly struggles and I have to jump up again and speak, that's what's happening, okay? So we're going to give it a go. We're going to have a Q&A bit at the end. So if you've got any questions, if you can save them till the end. However, I know sometimes you don't like putting your hand up. You always get a bit nervous and you think your question's a bit silly. First of all,
I don't mind putting my hand up.
you put your hand up, thank you. We've got a willing volunteer. Yay! And it's a man. We've not got many men here, so we've got about 4. So well done, you man. Anyway, so if you prefer to come and speak to us after the event, because sometimes you get a bit worried, we'll be hanging around as well after, or you've got all our details in the pack if you want to email us or phone us, whatever works best for you. Okay? So we are going to kick off with employment. I assume everyone can hear me because I'm very loud, but let me know if you can't. Right, so starting with the appointment of the employment relationship. So this is about getting it all set up on the right footing, okay? Because if you don't think about what protections you need, you don't think about status issues at the beginning, you won't appreciate what problems might come. And you might suddenly have liabilities you haven't even thought about. So you've got to try and get it set up at the right stage, at the beginning. What liabilities do you think the individual has on you? What do you owe them? What duties do you want them to owe you? What protections do you want in your contracts? Okay? Think about that at the beginning. Now, you may be thinking as I go through, oh, I haven't done that. I never thought about that. That's fine. Don't panic, okay? Because you can always review these things regularly throughout employment, and you should be. It's always a good idea to do it at pay rise time, because if, for example, you're going to be putting some of these protections in and changing the contract slightly, do it at the time when you're then going to give a pay rise, okay? Don't give a pay rise and then 2 months have to go, oh, by the way, will you suddenly accept these restrictive covenants? Because why would they? Use it at the appropriate times in the course of the employment relationship as someone becomes more senior, you know, at pay rise time, review them. And any changes you can make during that time, it's a better way to sell it to the individual. So, the question I'm going to ask you all is, who have you got in your businesses? You're probably thinking, what's she talking about? I know who I've got in my business. What I mean is, what is their status? Okay? How long have they been with you? What protections and rights do they have? Because status is a massive issue. You'll see cases all the time, the media goes crazy on it. What this means is, what rights does the person have? Are they really an employee, a worker, a self-employed individual? Because they all have different rights and protections. The key thing to note here is, these labels, which I'm going to talk about, the tribunal will look behind those and look at what the person is in practice. So it doesn't matter what you call them, what you think they are, the tribunal can change that, and actually it can change over time. So I still get cases where people phone me up going, it's all right, Katie, they're a seasonal worker, it's fine, they're seasonal, they're not an employee, they're not protected. I find out they're a seasonal worker who's been there for 5 years. Or a seasonal worker who keeps coming back every harvest. They can link their continuity together, they can get protection. Calling them a worker doesn't stop them being an employee. Their status can change, okay? An employee, what does that mean? It's probably the most common type of worker that most people understand. Employees work under a contract of employment. They are the people who come in and work regularly, whether part-time, full-time, doesn't matter what hours, but they come in, you control them to a certain extent, you expect them to come in, they get all the rights and protections under employment law, and they owe you the most duties. They're the people who look integrated and integral in your business. So if you have Joe Bloggs, an employee who's turning up every day, or even part-time, and you have Joe Bloggs, a worker, but they look the same to the outside world, calling them a worker won't stop them being an employee. The tribunal will look behind all that, and I'll explain a bit more later. So employees are the ones who get the most protections. I won't go into the long, boring list, but they're the ones who obviously can bring the unfair dismissal claims, the right to redundancy, they have the protection of TUPE. So if you have somebody who's been with you for a while, whether you call them a worker, whether you think they're a consultant and they're self-employed, and they've been with you for a period of time, and you suddenly want to end the relationship, if it's 2 years or more, please take advice, okay? Because we have lots of cases where Joe Bloggs is quite happy to be called a self-employed individual because he gets paid better, don't want to come on the books, but all of a sudden when the relationship's ending, he wants to be an employee because he wants his protections. So you will have lots of weird and wonderful, we call them atypical workers, who aren't your average part-time, full-time employee, and that is fine, and you use them for the right means, but if you're using these individuals long-term regularly, is it better to get them on the books? Because it might be that they have protections and liabilities against you you haven't catered for. So you might have paid them a high rate of pay as a consultant, for example, but they've been with you for 2 years. Then all of a sudden you end the relationship and they want a redundancy pay that you haven't catered for, or they bring an unfair dismissal claim against you. And because you won't have followed a process, you will be on the back foot. You will lose because procedurally it will be unfair. Okay? Now, if, for example, you have some weird and wonderful people hanging around, don't worry about it. Again, you can do that as part of an audit, do it as a review, think about, okay, well, that agency worker's been here a while, or that worker's been here a while. Is that someone who prefers to bring us on the books as a permanent basis? You don't have to admit any status issues with them, but obviously it's just something to bear in mind. Because also, what category of worker they are will depend on what contract you give them and what protections they have. So worker is a weird European concept. We blame Europe for this. So no one really knows what it means, if I'm honest. It hasn't got a definition. It's something that's not quite an employee, but it's not self-employed. It's in the middle. Obviously, agency workers, businesses use them a lot. They're great. They fill a purpose. You know, short term, or if you don't know when business is coming in, or to fill a hole, a gap, that's fine. Shouldn't be using agency workers long term, because again, they can become employees. If you're using a reputable agency, they will have contracts, you know, you'll have signed things, and you will probably be protected, but you need to check them, and they will probably pay all the holiday pay and all the things that they need to pay. You'll just pay your fee and they'll sort it out, and that's how it should be. But you need to be aware that workers, agency workers, can bring discrimination claims against you still, and holiday pay claims, if they haven't been paid the right holiday. So we've had a few cases where our client, the end user, has been using agency workers. Then suddenly there's been a health issue, or they can't come in because they hurt their back, something like that. Suddenly they don't want them anymore, our client, the end user. End the relationship, the engagement. Then the agency worker brings a claim discrimination claim, because workers can bring discrimination claims, don't need any length of service, and they brought them then against my client, the end user, who's just a business who just thinks it's using an agency worker, and the agency. And they can do that. And, you know, the employer could potentially be liable under discrimination law. So that doesn't mean don't use agency workers and don't be scared, but if you've been using agency workers for a while, or a person, suddenly there's a health issue, for example, just maybe take advice before you end the relationship, just in case, because they could bring a claim against you for discrimination. Okay, don't just assume they're not my problem. They could be a problem if you don't deal with it correctly. This is all about just keeping things on the radar and taking advice before you do stuff to make sure you're protected. True self-employed individuals, you know, your window cleaner, your gardener, your builder who owns a company and does jobs here, there and ever, they're true self-employed individuals. A true self-employed individual is not a consultant who's worked for you for 5 years on a long project. That is not a true self-employed individual. That person will be an employee, okay? And it might all be great and fine while the relationship's going on, because people tend to talk to us when it all goes wrong. And then these are the problems that we see. That, oh, we've had somebody working for us. Don't worry, they're a consultant. Don't worry, Kate, they've got a document calling them a consultant. Got a consultancy agreement. I've got it all signed and protected. Right, I've ticked all the boxes, I've got a contract. That contract won't protect them. If in practice that person is actually an employee. Okay? Just be wary. So, if it looks like a duck, swims like a duck, quacks like a duck, it's probably a duck. So that's what I've just been saying. A label will help, but it isn't the only factor. The courts, the tribunal, the revenue are hot on this. You know, tax issues are major, and Paul will know all about that at Foresters. So it's not just an employment liability. If you've been treating somebody as a worker, self-employed, paying them as such, they suddenly bring a claim against you, you've got potential liabilities. They will look behind the contracts. Even if they're drafted by me at Wilton Chapman, and they'll be amazing, they won't protect you if in reality they are something else. Okay? We had a case with a building company, I felt really sorry for this guy, trying to get people on the books. He had builders working for him 5-6 years, etc. You know, he called them subbies or whatever they're called, contractors on building sites. He kept trying to get them on the books, kept saying, oh, come on, you know. They didn't want to be on the books because obviously they got more favourable rates of pay, etc. That was all fine while they were getting work. All of a sudden, building trade, you know, didn't have a job for a while, just said to them, sorry guys, don't want you to come in anymore. They all brought unfair dismissal claims and redundancy claims, and they all succeeded. Because it ended the relationship without following a process, and the court held they were employees, so they were entitled to redundancy pay, all of them, and also they won their unfair dismissal claims because they hadn't followed the process. You know, the building company owner didn't think he was doing anything wrong. Phoned us after the event. If he'd phoned us before, we'd have still ended the relationship with those people, but we'd have done it the right way. We wouldn't have omitted anything. We wouldn't have said, oh, you're an employee, but we'd have ticked some boxes. So if they did bring claims, the claims would be worth a lot less because procedurally we'd have ticked the boxes. So, you know, this doesn't happen a lot. I don't want you to be worried, but it's just things to bear in mind, because I still have cases where when the relationship ends, the agency worker, the self-employed person suddenly wants to be a employee.
In the case you just described, why wouldn't the industrial tribunal take into account the fact that the employee tried to bring them on board and they didn't want to?
The tribunal did, and it would, you know, it's got discretion in how much compensation it awards, and we don't know what it would have given the individuals without. They didn't say they were making a reduction because of that, but that's not a defence. They look at black and white. They look at, is this person an employee? Yes. Have they followed a process under unfair dismissal legislation? No, because they hadn't, because they didn't know they were employees. So I'm sure the judge did, because a judge is a normal person, they're a human being, and they understand that it's difficult. But legally, they're not required, because that's not the tests.
Thank you.
That's okay. Right. So you've got lots of different people in your businesses. You've also got lots of different people in relation to, you might have shareholders, directors, partners. These are all people who have different hats, okay? They all have different rights, different protections. You owe them different duties. So I'm not going to go obviously into like shareholder issues, because obviously I'll leave that to Adam. He's the expert in that one. But all you need to think about as well is that you might have, especially for a family business or a smaller business, you might have a director, shareholder, employee, all having different relationships. And I get clients phoning me all the time saying, oh, we've fallen out, blah, 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 blah. You know, he's selling his shares, I've just dismissed him. Because they assume that the removal of one hat, shareholder, would remove the other hat. That is not the case. They are all different hats, they are all different statuses, and they all have different protections. So the ending of one does not automatically end the other. You need to make sure your documents all join up as much as possible, you know, shareholder agreement, which Adam can help with. If you've got directors, which are basically hyped up employees most of the time, they need director service agreements, which again is just a more tighter contract of employment with more restrictions in, more protections in. But we can cover in those documents the fact that obviously if they leave, they're no longer an employee, they're no longer a director. We can cover all the protections and restrictions that you would need for someone of that level. Because generally those people are the most important people in your business who can do the most damage. But they're the people we see time and time again who actually aren't protected. I spoke to a client yesterday and they were just like, oh, well, you know, it's all fine, we're all happy, we're all getting on, everything's okay, we don't need these things. Well, that's great until the relationship falls apart. And then you will see, it's like a divorce, everyone's fine when it's marriage, aren't they? And then suddenly when they're splitting up, we see it all the time in our matrimonial department, people fight for their rights. And that's what we see here. Adam and I deal with family businesses, don't we, Adam? All the time. They are the worst because they don't have the paperwork, because they, it's probably set up small, got bigger, haven't protected themselves. And then when it goes wrong and it gets then even more personal and emotive because it's often family connected, they're not protected in relation to this, and then suddenly they have an unfair dismissal claim against them because someone's been there 20 years, being paid an employee, and they just want to end the relationship. But they haven't got a fair reason, and they've got no documents to protect them. And then the director leaves and sets up in competition next door. That director is obviously the person who's probably got the most information, can harm the business the most. But again, because they've got no contracts, they've got no protections. So they're the people who can do the most damage, but we don't have any protection. So again, I recently just reviewed for a family business. They said, oh, we've got bigger, we've grown over time, we didn't expect to be this big, we started off really little, we didn't have the right documents, can you now introduce them all? They're all the same roughly for all the directors, all the shareholders, all the employees, so it's fair because they're all having the same protections, and ultimately it's to protect the business that they own. So, it'll apply to all kinds of businesses, big and small, but you just need to make sure you get the right bits of paper and don't just assume that ending of one ends the other. Take advice first. So why have a contract? Well, I'm sure you can tell by what I'm saying, it's really important. Okay, it's not just me making more money for Wilson Chapman trying to get you to review your contracts and produce jazzy things. It's a legal requirement. You have to give a contract to an employee. If you don't, and they bring a claim against you, they're entitled to compensation, 2 to 4 weeks pay. Okay, so generally people don't bring standalone claim for, oh, I haven't got a contract. They bring it along with other claims. So when the relationship ends or something happens, they add this claim, failure to provide terms and conditions, to all the other claims, obviously to make it look even worse and to get more money from you. So it is a legal... Yes, Mandy?
So if you've issued a contract to somebody and they haven't returned it, and you've sent an email and reminded them that you need the contract returning, if after, say, 3 months after giving them the contract they haven't returned it, is it being served?
Yes, so I'll cover that in a minute, but yeah, that's right. So that ties into getting them signed and returned because of restricted covenants, not an issue. So I'll pick it up, but if I don't answer the question, let me know. So it's a legal requirement, so you've got to do it. There's a big list of what you're meant to include in contracts. I won't bore you with it all, but if you get a lawyer, anyone decent, people like us to review your contracts, we will make sure they tick those boxes. Okay. I get people all the time going to me, don't worry, Kate, I haven't given them a contract. I didn't know if they were going to be any good. Well, they've been with me for 3 years, but it's fine. They haven't got contracts, so I can just get rid of them. No, it's not fine. They are still an employee. They have all the rights. You have no protections. These things that I'm talking about isn't me just being difficult. It's to protect you, the business, okay? It's not to protect the individual. It's to protect you. Because the employee will have all the rights to be paid, the right to minimum wage, the right to holidays, the right to bring an unfair dismissal claim. They will have all the rights and you won't have any protections. There are very implied rights, there's very minor implied rights that they will have, such as you'll have some confidentiality rights, but they're really minor. So for all the beefed up protections that you need these contracts, okay? It's for your benefit. Also, there's nothing worse than going to tribunal and sitting there and the judge goes, oh, Mrs. Davis, oh, where's the contract? There isn't a contract. You look like you're on the back foot. The judge instantly takes dislike to you, thinking that you're not a reputable business. You don't take employment law seriously. You look unprofessional. You don't look, you might win your claim, unfair dismissal, because you might have followed process, but you're going to lose in relation to not providing the contract, and you're going to be on the back foot. So it's in your interest. And also, I'm going to talk about tailoring them and all the things you can do in a minute, which make them worth their while, really. Again, like I said, if you haven't done this at the beginning, don't worry. You can always review contracts. You should be anyway. I always say the line of, oh, we've just been reviewing our contracts to make sure they're in line in legislation because there's been some new updates. Now, the updates are about 3 years ago, but they don't need to know that. So, and then you can do it, like I said at the time, you're giving them a benefit, pay rise, something that they're getting in return. And if they don't want to sign that new contract, they don't get the pay rise. It's as simple as that, okay? So, in these contracts, you can tailor them, make them fit your business. Every business is different, okay? What we do at Wilson Chapman, we try and get to know anybody who works with us. We'll try and get to know your business, know what's important for you. And some businesses don't care about restrictive covenants that I'm going to talk about in a minute. Some businesses do. Every business is different. I have businesses who are care homes and they need things about DBS. They need things about manual handling. I have driving companies, they obviously need driving licence provisions. I work with security clearance companies, they need security clearances. There's all different things that you can put in your contracts and tailor them to your business, okay? This is what you use the contract for. Obviously, you'll have things like pay and hours of work and all that kind of stuff. But you need to be putting things like garden leave provisions. So if somebody leaves and you want to protect your business, you can put them on garden leave. You need to put training recruitment clauses. So if you're paying training out, if they leave in a certain amount of time, you can get the money back, enhanced maternity, things like that. So that, great, give them these benefits, but if they leave, that you've got the power to recoup money, get the money back. If you don't have a deduction clause in your contract, you cannot deduct money. It's a breach of contract. So you need that in your contract. Confidentiality, okay, there's implied duties under law which are very low, but if you've got a senior person or any person really, you don't want them going stealing your data, your customers' list, whatever is relevant to your business. I have businesses that have all kinds of things that are confidential. That can be covered in the contract. Otherwise, what you're relying on is a really low level return of company property, things like that. Restrictive covenants, IP rights. IP rights are if people are inventing things. They won't be relevant to all businesses, but some of my clients invent things or they have architects and things like that. If you don't have IP provisions in your contract, then the ownership of those IP rights doesn't pass. Again, they won't apply to every business. They're just things to think about. What does my business need? How does my business need to protect itself? So restrictive covenants, and this will answer your question as well, Mandy. Restrictive covenants are things that protect your business when you leave, okay? So again, I get clients going to me, oh, don't worry about that. We don't need to think about that. They're not going to leave. People do leave all the time. Relationships fall apart, or they just leave because they get another job, or any reason. It doesn't need to be good or bad. And then if you don't have restrictive covenants, you have nothing to protect yourself. So if they go and set up in competition, if they go and contact your clients and customers because they can get them off Google, which most people can nowadays, if you have no contract, no protections, you have no rights. Restrictive covenants need to be signed and accepted, Mandy. So, for example, if you've issued that contract, whilst they've accepted it through custom and practice by accepting pay, so in your situation, they have accepted the contract because they haven't objected to it, or have they objected to it?
They objected to a clause in it.
Well, you need to go back and
But I went back by email and said, no, it's that clause stands.
and have they come back to that email? So then I would probably email again to just say, for the avoidance of doubt, you've been working under this contract in X, therefore it is implied by custom and practice, and if they object, you'll have to come back to me, maybe that's a whole new episode. But restricted covenants had to be signed. So I get this all the time, I get clients who've done really well, they've got the contracts drafted, they've issued them, they're all happy with their little selves. Then they get busy doing something else, because I know you're all really busy, and I get that, and like Mandy said, you're chasing people from the back, which is really annoying. And then they leave, and I say, come on, where's your restrictive covenants? Let's send them a letter reminding them they can't do X, Y, Z. Oh, I didn't get a signed contract. Right. So they are things that have to be signed, otherwise they're not valid under law. So don't do all the hassle of doing all these things and not get them signed in return, because then you can't rely on them. You've done all the hard work. I know it's a nightmare having to chase people, but I mean, get to the point where, Mandy, you say, well, I want to have a meeting with you about this, sit down and talk about it. And as soon as people have to sit with you face to face and explain what they don't like, might be more willing to accept it. And again, if you're introducing things like restrictive covenants and you're doing it at pay rise time, unless they sign and accept those restrictive covenants, they don't get the pay rise. You're entitled to do that. They can't have cake and eat it. What you don't want to do is give them the benefit of the pay rise, then the month later talk about introducing extra notice pay or extra notice periods or extra restrictive covenants, because you're putting more restrictions on them, which they won't like, obviously, and you've got nothing to barter with. So use it at the time where you can give them something back so you look like a really nice employer. Okay? Not one size fits all, right? If you had a leaky roof, you won't go on the internet and just buy a new roof, would you? Okay, one size does not fit all. You still have a leaky roof. They'd come and measure it. They'd check it. They'd get to know your house. We get to know your business. A decent lawyer will get to know your business, understand what you need. So do not buy them off the internet. I mean, obviously I want you to come to us, but even if you use somebody else, that's fine. Don't buy these contracts off the internet because they won't protect you. I saw restricted covenants in a contract recently which stopped somebody working in competition for 5 years. I mean, there's no point even putting them in. Restricted covenants have to be reasonable, okay? Courts don't like them, so they have to be reasonable. So the more senior you are, the more longer they can be. But if you work in Grimsby, for example, you can't have restricted covenants for 5 years that stop somebody working in the whole of the world. That is not reasonable. So yeah, I saw these contracts 5 years, I mean, it was just ridiculous. They're not going to be valid, so there's no point even putting them in. If I got sent them, I just laugh at them, okay? So make sure you tailor them, because all those things I've talked about, if you need security clearances, if you need somebody to have a DBS check, if you want them to go and work abroad for a certain amount of time, which some of my clients do, you can tailor that and put, this is the opportunity to do it in the contract. And most employees nowadays will get it. They understand they want clarity. They want certainty. Both parties want to know what's going on. Because it's positive, not just negative. I can't sound like all of them saying restrictions, restrict your employees, stop them doing anything. What I'm also saying, it's nice and clear. There's nothing worse than when there's a dispute and no one knows what they should be paid, how many holidays they should get, how they request their holidays, what they do if they leave, how they protect themselves, where the GDPR policies are, what the GDPR policy says. Everything that's clear is better. Hopefully it will avoid the disputes. And, you know, people nowadays expect it. You know, it's difficult now trying to get good candidates. There's a shortage of good candidates. You want to make sure that you get the best person and protect yourself. And if they're a good candidate, they should expect that you as a business are going to want these protections. It's what they would expect to see. And if you don't, you're on the back foot. If you offer things like medical insurance and all nice extra benefits, this is your opportunity to sell it, put it in the contract, make it nice and clear. This is a good thing as well as, you know, a protective thing for the business. You can put in contracts things like share schemes, but I'd normally recommend you speak to Adam about something like that because Adam can deal with lots more things than I can. That's his expertise. We obviously work together, but I would normally, if you want some kind of shareholder protection, I would normally recommend you speak to Adam. Bonuses, okay? One thing I want to say about bonuses, if you have bonuses, you know, sometimes we have some good schedules at the back of contracts which explain them a bit better. If they are discretionary, make sure they are discretionary. I won't name any names, but I have lots of clients who call bonuses discretionary, but they give the same amount every year to everybody with no explanation, just, oh, here you go. So the employee's expectation is, no matter what I do, no matter what the business does, I'm going to get that money. It becomes contractual over time. Calling it discretionary in the contract, again, it's a bit like the status issue, won't stop the court holding that actually it's contractual. So if you are doing bonuses or anything that you do that's really good, benefits, make sure you say, we're giving you this because you've done X, Y, Z, or because the business has done well. It is discretionary. And make sure you vary it and jazz it up a bit so it's not always the set £250 every year to every employee, which is fine, but you might create a precedent that you've got to do that every year for every employee. So just bear that in mind. So if people leave and we've got all the nice bits of jazzy paperwork and we can protect ourselves, then the first thing I would say is, can you send me your signed contract? And obviously, because you've all listened to me, you'll all have nice signed contracts, so that will be a plus. You know, people often leave and there are no issues, but it's always a good thing if someone's going to leave, especially if they're senior, to send them a nice little letter just saying, I'm really sorry you're leaving, and then reminding them of the protections and their obligations to return certain things, to do certain things. You know, if they've got to remove themselves from company's house if they're a director, reminding them of any restricted covenants, reminding them of confidentiality, because 9 out of 10 times that's enough. You know, people realise, oh yeah, I've got those, forgot about those, or yeah, I know I've got to, you know, it puts it in the head and also it makes them know that you're on it, okay? If then they breach it, we have power to do something because we have signed contracts, we can take action. You know, I'm not recommending you all take injunctive proceedings against people because they can end up being very expensive. But it's normally enough to get our litigation department who can write very stroppy letters, more stroppy than mine. If you see mine are quite stroppy. More stroppy than mine, saying we will do X, Y, and Z and relying on the contracts that have been drafted, okay? And that is normally 99% of the time enough. Sometimes it isn't. Sometimes we have weird and wonderful situations with employees who are on a mission and you have to take action. But if you haven't got the right bits of paper, you can't protect yourselves, okay? I'm just going to turn to handbooks, but I just wanted to say one thing about holiday pay, which I haven't mentioned. It's only because there's going to be potentially another decision. So workers, that weird category, they get holiday pay like employees do. We're seeing quite a lot of individuals contacting us, and we generally don't act for individuals, we generally act for companies, as you know. We get quite a lot of inquiries about, I haven't been paid the right holiday pay, or employers are contacting us to say, we've got these agency workers, or we've got these workers, and they're saying that they should get holiday pay for this. Workers are entitled to holiday pay. It should be including overtime. I've still got clients who are not including overtime, and they should do. At the moment, you go back for 2 years, and then that's it. The work can only go, which is long enough in itself. But we are aware of that the courts are looking into this, and there's some guidance to suggest that the decision that puts this gap of 2 years, the break of 2 years, may go, and then they'll be able to have back pay forever, basically. So don't worry, it's not a binding decision yet. Okay, we're waiting some more legal authority, so it won't be next month or anything. But holiday pay, give yourself a holiday pay audit. I know it's really boring, and sometimes you can spend hours on it, but just have a general look up, particularly in relation to workers or employees who are getting overtime or commission. Are they being paid the right amount of holiday pay? Because you can rectify issues now, so that if they do bring in claims, you're stopping liability. Okay, I won't go into any more of that because it's quite complicated, but just something to bear in mind. So I'm just going to talk about handbooks very quickly because they are dull, and then I'm going to hand over to Lily, see if the voice holds up, and then we'll finish off. So handbooks, key thing to know, short and sweet, okay? I don't like long handbooks, the less said the better. Can't believe I just said that considering I don't stop talking. But in your handbook, you need to keep it short, because if they are too long, nobody knows what it says. It's in the find it when I go to see the client, they find it in the bottom of a drawer and they dust it off because no one's ever looked at it. They don't know the employer what's in it. So if they don't know, how's the employee meant to know? They'll end up being breach of it, okay? Handbooks should be non-contractual, okay? So you can amend them without having to consult and get the employee's consent. So your key things are in your contract, okay? Your handbook shouldn't be having key things about, I don't know, sick pay, in my opinion. That should be in your contract, each their own, but, keep your contract simple. If you have any weird and wonderful things and you have visions, I often see in handbooks, which is fine, visions, our vision of our company is X, we have this ethos, which is really important. Put it in your handbook. That's what your handbook's for. That shouldn't be in your contract, okay? That should be in your handbook. Keep them under review. When you get a new employee during the induction, get them to read it or at least take it away. You don't have to sit there watching them, but at least get them to sign something to show that they've read it, they understand it. Because I have loads of cases where the first thing the judge will say is, "Oh, Mrs. Davis, when did they see this handbook? Are you, is your client aware that they read it?" We have to try and find a bit of paper, but it's like 10 years ago. So induction, then keep it under review. Maybe at appraisal time, have a little box on your form just saying, "Have you looked at the handbook recently?" It's not your requirement as the employee to sit with them and make sure they read it. It's your requirement to say, "Have you looked at your handbook recently? Are you up to date?" They'll just say yes, because they won't want to read it. But that's fine. You use your handbook to put any kind of niche policies in. So I've got clients who have manual handling policies for carers, or I have clients who have lots of health and safety policies and asbestos and all those kind of things. Again, you can use that in your handbook as well. If you've got any really important policies, you may want to issue them separately. I've got a client who asbestos is the big issue, so they will make sure they deal with that separately to give it, to make sure it's not lost in the trees. I thought I'd just give you some examples of. I thought I'd show you a handbook. This is from 1925. So this is John McIntosh, and you're all gonna. I just read this, and I'm just back in the day. So it's got some sections. I don't recommend you put any of this, by the way, in handbooks. It says. Any woman employee will, in the event of getting married, be given a dowry of £1 for every complete year of service, provided she's been there for at least 3 years. And in view of the present state of trade, any woman employee getting married on or after January the 1st, 1925, will automatically cease to be employed. Angie's like, I'm putting that So don't obviously be taking that. And I think, in this, I can't believe in this room, I think we're 95% women, so we'd all be sacked. But then it's also got a lovely little section about, we think care of teeth is very important, and we'll give you some money for dental charges and care of eyes. So actually, on the one hand, all your women get dismissed. But on the other hand, it gives them all money for medical services. It goes over and above what you would expect. And then if you worked in America and you wanted a handbook for Tesla, who are, as we know, renowned for saying things all over LinkedIn and Twitter, it says, if you're looking for a traditional employee handbook filled with policies and rules, you won't find one. Policies and rules tell you where the bottom is. They tell you how poorly you can perform before you get shown the door. That's not us. We prefer to have high standards. Is this you? If so, we're glad you've come and we look forward to working with you. If this isn't you, you'll be more successful somewhere else. We don't mean to sound harsh, it's just the truth. And it goes on and on. It's got a section saying, something stupid. If you do something stupid, depending on the circumstances, you may be coached and given another chance. we can't afford to waste our time dealing with stupid people when we have more important things to do. It goes on and on, honestly. It's so, but we got a few minutes, didn't we, Lily? Client. And first of all, I thought they can't really be their handbook. But to be fair, it's straight to the point. It says if you have any days off sick, that's it. We don't do any sickness. Don't do that. There's a happy medium, but I've got that cheer up. So I think I've covered. Oh yeah, you've obviously got key policies like disciplinary grievance, flexible working, whistleblowing. Those are the kind of key policies, equal ops that you need to make sure you've got. There may be other niche ones that you need to have. We can assist you, do reviews of your documents. We've got a lady in the team called Tracy, who's the HR advisor, and she does lots of these regularly. So she's used to preparing and seeing what other people do. We've got lots of precedents, so we can assist you with that if you need. Right, I'm going to hand over to Lily, but if I have to suddenly jump up again,
I'll do my best.
otherwise it's done. Sorry, Lily.
Which one is this one?
Oh, I'm on it. You're on it already.
I'm going to let it catch up.
There you go.
Right, hi everyone. So as Kate said, my name's Lily. I've recently qualified into the employment team. So I'm just going to talk through a couple of slides on job descriptions. So might not be as quite as excited as Katie's bit, but I'll do my best. So yeah, as Katie was speaking about, obviously the beginning of the employment relationship, normally that's the point that you'll be looking at putting together a job description as kind of one of the initial steps when you're going out to recruit, or if you're creating a new role or someone's promoted into a new role, and then maybe it goes in a drawer and you forget about it. But it is actually good practice to keep reviewing them, not all the time obviously, but every couple of years, review them, make sure they're accurate and up to date as roles evolve over time, and also to keep it in line with the goals of the business as they may change over the years as well. So there's no strict legal, it's not like a contract, there's no strict legal requirement to have one, but obviously it's good practice to do so. It gives employers the opportunity to hone in and focus on the skills and requirements for a particular role, and to provide a neutral and objective set of criteria to do that. So in terms of what they do, obviously there's some points set out there, I'll just go through those. May seem quite obvious. It allows you to identify the key tasks and responsibilities for a particular role. Again, as we've mentioned, with fair and objective criteria. They can also be helpful to provide some clarification if disputes later arise during the engagement, as obviously the position and what's required is set out clearly from the outset in one document. It in turn helps feed into looking at what training may be required, so what are the requirements, what needs to be covered for somebody in that role, and also that's within the scope of the duties. Preparing one as an initial step in the recruitment process can also help feed into preparing a person specification, if that's what you do as well, to look at what skills and level of experience you're looking at for that particular role. And another point is, I'm not sure we've got this on the slides, but it can help set expectations on how performance will be managed as well throughout. So you've got kind of the benchmarks and the requirements of the role that you'll be looking at, to assess performance and how well they're doing. So ultimately, there's a number of benefits in using them for both the business and also for the employer, as obviously you've got it set out clearly in one place. Please, next slide. So what to include? Self-explanatory really. The first point is obviously the main purpose of the job. You want to make sure that you're describing accurately, not going into tons and tons of detail, but generally a summary of the tasks that are involved, the key ones within reason. Obviously, it's not going to be every single thing that they may be asked to do. The scope of the role, I think there can also be a good opportunity to set out how they fit into the business, so who do they report to, who reports to them, how it fits in and works with the business. A lot of the guidance suggests it's good to focus on outcomes rather than being too rigid in kind of how tasks need to be performed. The emphasis with that is because you want to avoid any inadvertent discrimination by saying it needs to be performed in this way. If you kind of adopt a tone of an outcomes-based approach, what the role is intended to achieve, that can be a better way to do that. Another pointer is to where possible to avoid being too rigid with the work pattern. So does it need considering whether you need to have it as a full-time role? Are you saying well, all our senior staff are full-time, so it needs to be full-time? Again, we'll just say it's best to consider that, whether an alternative kind of hybrid arrangement or just can it be part-time. Again, that's to kind of avoid any potential risk of indirect discrimination. The key example when you look at the guidance is kind of saying, does it have to be full time? Typically, the statistics show women bear more childcare and responsibilities, so it's avoiding challenge from that perspective, really. Job titles, it's again quite self-explanatory. Obviously, you just need to be thinking about this clearly. I would say we're probably past this, but again, the examples that they give is kind of avoiding titles like shop girl and things that involve characteristics which are kind of predetermined and based on a characteristic that's not, a fair basis. So the key point with that is just to be as neutral as possible with the job title itself. And just to emphasise, the final point is just to remember it's not an exhaustive list. Just a summary of the key tasks and responsibilities, not every single thing that they may be asked to do. So as you can have in contracts sometimes with, and other reasonable duties that may be requested by, managers, flexibility can be used. But again, that's within reason. It's not a kind of catch-all for any job that's completely unrelated to anything else. A key with that is just to be sensible, try and be as accurate as possible, and then within reason you can put in what you like. Katie did tell me about an example where I think one of the requirements, the job was stated to be part-time on the job description, and then one of the requirements said, you're expected to be available at all hours whenever called upon, so you might not have many applicants in that kind of situation, but I'm sure none of you do that, but it's just generally being sensible and reasonable with the points that are in there. So that kind of concludes my section. I'm going to hand back over to Kate to do some top tips.
Right. I'm only going
Might jazz it back up.
No, I'm only going to say because we're running out of time. But we've got a question, Lo.
Very quick one. In terms of the job description piece, if we ask people to sign them, does that then not become a contract by nature, and therefore it's difficult to vary them and not rely on the other duties kind of element?
It depends if your contract refers to your job description, because then it will form part of your contract of employment. But no, a job description, if you get them to sign it, it's just signing to show that they've accepted it. And as long as you've done that and saying this is a non-exhaustive list, and you may be required to do other duties within your skills or competency, the usual one, that it's got to be something that's reasonable.
Yeah.
So, but no, it won't become a contract. But obviously, if you are amending their duties over time and they're outside of scope, you're going to have an issue anyway, because it might be that you're no longer trying to employ them with the job, and that refers back to the contract because the contract will have their job title. So it depends how much you're changing it, Lo, if that makes sense.
We have a lot of backwards and forwards on that front around it. Kind of gives people permission to work to rule by having it signed in that way and going, well, it says here that's what I do. So it's all about that, how you frame it.
That's why I think less said in a job description is better, because I've seen JDs that are 4 pages long, and because they're so long and cover so many things, you're creating a case for yourself, because you can say, well, in 4 pages it doesn't say that, whereas if it's just a general, you will manage a team, you will be charging X, you will work on the docks and do any duties within that, keep it looser, Lo, I think, if you're getting that kind of problems, within reason. That has
If you've got a part-time contract and it's a co-worker situation where you've got a job share, and the job share, other oppo if you like, off ill or on holiday, would it be wrong to make that part-time person work the full hours? So say you've got to cover your co-worker if they're off.
Right, so generally probably if they've been working for 3 years and suddenly you're trying to change it to that, then I don't think you'll be able to do that, Rachel, unless they agree, because you are fundamentally changing their job. And me, for example, I'm part-time, although I work because I work nearly full-time hours, but obviously if someone said to me suddenly, you have to change your hours, I wouldn't be able to because of childcare. So it depends on the circumstance. If you put in the flexibility clauses and all those things in your contracts, you may be able to rely on that to a certain extent. But it's like anything, if suddenly you're requiring them to work full time for a period of time and they can't because of childcare or because of whatever reason, you are changing their contracts. So
what if they've gone from full time to part time and that was kind of part of the agreement?
So if at the point they went part time to full time to part time, if the agreement is clearly you will be required to work additional hours and you may be required to work your full time hours if the job shares uphill, that is part of your contract. It's all going to be how your contract's drafted. And also, it's like anything, you can have something in your contract, like mobility clauses, you can have those in your contracts, and they help if you want to suddenly move them. But if they've worked at the same place to work for 6 years, it's harder. So your contract will help, so put it in your contract, because if you haven't got it in contract, you can't even rely on it at all. But it's also what's happened in practice. Okay. So I'm going to hand over because we'll run out of time. Get your contracts reviewed, get them signed, accepted. contact us. That's your top tip today. Sorry, guys.
Right, good morning, everybody. I'm going to push that misconception that all accountants talk about is tax and figures and things, and probably 90% of what I'm going to talk about today doesn't really have any figures in there. So that's a bit about me, and yeah, you can quite clearly see that's me. So I'm going to scoot past some of this, and that's about Forrester Boyd, but most of you will have heard about Forrester Boyd, so you don't need all that background. So straight into it, areas that I'm just going to cover on, talking about business planning, SMART objectives, which you may or may not have heard about, and then touching upon financial forecast, which is a topic in itself really, and I could talk at length about that. But some initial questions really, just to provide some context. What do you want out of life? Why is an accountant asking that? That just seems a bit odd, doesn't it? But it's about getting that balance really. What makes us happy? We lead our lives by certain things. We've got our own personal aims and aspirations about what we want out of life. It might be to save up and go on that Florida trip to Disneyland or whatever in a few years' time or whatever. We don't necessarily always write those things down, but they're there in our heads. And by extension, that's sometimes what happens with business planning as well. It's in people's heads, but they're not writing it down really. And we might need to consider that. But it's a question of why are we in business? And it might be that we're in business because we've got some sort of niche skill. We might be really passionate about what we do within business. We might like the flexibility of being self-employed, that sort of thing. Providing family security, that sort of thing. Loads of different reasons. But generally, business and what we're doing needs to support our personal aims and aspirations, and getting that balance right is quite key. So that's sort of me talking about well-being. It's sort of strange, isn't it, coming from an accountant, but there you go. Where do you want to be? It seems obvious. Where do we want to be in 5 years' time? I speak to clients, prospects, ask them this question. It takes them back sometimes. Why are you asking me this sort of thing? I just want you to do my accounts. But the answer to that is that then comes down to the advice that I give. It might be that they want to retire early at 50. They might absolutely hate the idea of retirement and not be that person that's just going to sit and do crossword in the armchair and want to wait till the 70. So completely different aspects there and completely different ways of advising. There's no right or wrong answer to that question. It just leads on to, well, we need to be aligned really in the advice that we're giving. Another question, I think then we're through the questions. What's your exit strategy? It's another question that I ask people, even if it's a brand new prospect client that's coming to me with this idea for a business, thinking about setting up in business, going self-employed, that sort of thing. And I say, right, what's your exit strategy? Well, hang on a minute, I haven't decided how I'm going to set up yet. Why are you asking me that question? But again, it's where do we want to get to? The advice depends on that. We need to be planning for that exit. So it's very important. It impacts on what structure we're going to go into. Are we going to be self-employed? Are we going to go into a limited company? All those sort of different sort of questions really there. I'm throwing them all out here, aren't I? Why have I put this on here? We probably don't really have those in our cars now either, do we? But with this sat nav, we know we put in there. We know where we want to go. So we're going on a journey. We're going on holiday. We're doing whatever. We're going to the airport. We're going to see family. This, that, and the other. We'll stick the postcode in, and sometimes we will just follow that. 9 times out of 10 people just follow that, and it might take us a long way around or whatever, but we follow it. For the men in the room, we probably decide that actually we know better and we're going to go a slightly different way. But the concept is we're putting in a destination and then we're following the route. And we may go a slightly different route, it may be an out-of-date sat nav like this. The maps might not be up to date. It might send us the wrong way up a one-way street, for example. We obviously then need to go a slightly different route when we see. So the whole point is that we know where we want to go, but we may go a slightly different way, and that's absolutely fine, but we know what the destination is. So it's just important, and this extends to the business plan. If we know where we're going to get to, we can then navigate the route. So coming on to the business plan, there's no right or wrong way to do a business plan. People may say, well, there's fundamental things that need to be in there. This is my take on what needs to be in a business plan. Other people might say slightly differently, but these are some of the key areas. It may be an informal business plan. It might be something that is just for your own self-accountability to keep yourself on track. It might be something that we're sharing with the team, key members of the team. We might be sharing it with finance providers, investors, that sort of thing. So depending on that, it may need to be slightly more formal. But this is the key concept. What do you do? That seems really obvious, but it might be obvious in our heads. Sometimes we might actually need to remind ourselves what we're doing. It might seem obvious, but particularly if we're sharing this out to other people, it's quite important to get that down. But yeah, likewise, very useful to remind ourselves sometimes what we're doing. What problems does your business solve? What's the solution? Not to be confused with the first point about what we're doing. This is about what we're solving. And somebody once said to me, and it's sort of stuck in my head actually, is that we sell beds. That's what we do. We sell beds. But what's our problem solving? Well, actually, we're selling a good night's sleep. That's what we're doing. That's the solution. And so then that allows us to focus things like marketing strategy, for example, on the problem that we're solving, as opposed to, well, we've just got this product for sale, sort of thing. Who's the target market? So, if we know who the target market is, then we can direct things in different ways. So again, coming back to marketing strategy, for example, if we know who our demographic is, who we're trying to target, we then know that how we can focus our efforts on marketing that product, where those people are going to be, whether it's on social media or something like that even. It just gives you focus, really. Competition. What's the USP? What's our competitive advantage really over other people? There's competitors locally, in everybody's marketplace, nationally, but we're even competing really on an international scale now. We've really got that with the rise of online, all that sort of stuff. So what's our competitive advantage? Again, giving us focus really. Products and services as well. So yeah, we might just literally put down what we're selling, what our services are, but by addressing that and actually writing that down, it probably then allows us to then think about, well, what else could we be doing? What other products are there out there? What other added services could we do that fit in with our overall strategy, our overall objectives? Key expenses, it might be that we're very heavily labour based, so Wilkin Chapman, Forrester Boyd, we're very reliant on people. It might be that we're a manufacturing business which has got a bit of a balance between labour, manufacturing things and the product itself. It might be that we've got a heavy reliance on logistics. By defining those sort of key products, those key expenses, it highlights then that we need to be focused on that, so then we can respond to things as they're changing. Brexit, for example, caused quite a few issues with people from a logistics point of view, that we're sort of pushing things out into Europe. Those sort of things being highlighted in the business plan, actually sort of noting those down, make us sort of accountable and being able to respond. Key dates and milestones, doesn't matter what they are. It might be that we want to hit £50,000 turnover next year. It might be that we want to hit £10 million turnover in 5 years. Two completely different businesses. It doesn't matter what that is, but putting a key date milestone gives us a little bit of focus there as well. Who's in the business, and this links back well to what Katie was saying earlier about directors, shareholders, staff, and then what Adam's going to talk about later about shareholders and protections and things like this. So who are those key people? What's their remuneration strategy? Have we got all the right documents in place? That sort of thing. Helps also to highlight those key staff that within the business from a succession point of view. Because are those people going to be the future of the business? Are those people going to take over from the existing directors and owners of the business in the future, something like that? So noting those down, making sure they're remunerated well, that we're looking after those people in the right way, as we should do with all our staff. And do we have the resources available? In the context of everything that we've covered off there, do we have the resources available to do all of that? And it might be that we do now, but we might not in a few years' time. If we put in a milestone date and turnover targets and things like that in a few years' time, does that then prompt a question about, well, the resources, they're not available yet, but we will need those resources at some point in the future, and where are we going to get those from? It might create more questions than it solves. The answers to those questions may create more questions, but it just shows that we're thinking, we're brainstorming all those sort of ideas. There's loads of templates online for business plans, similar to what Katie would be saying and has said about different contracts and things. They're not always the best thing to look at. You could take different bits from different templates and forge your own. What I would suggest though is that you don't just copy and paste one and then send it to the bank manager, because it's not tailored to your business. It needs to have thought. Brainstorming a business plan with professional advisors, with family, with friends, with the team, those key people within the business, is really, really worthwhile. It can create more opportunity and new, fresh ideas really as well. So just touching upon objectives, I don't know if you'll see that, but SMART objectives. So SMART stands for specific, measurable, achievable, relevant and timely, for those that can't see that at the back. You may or may not have come across this, but just briefly, this is really to make sure that we're aligning the strategy with the overall objective, the overall business plan. Suddenly people have this spur of enthusiasm, New Year's resolutions or going away from today. It might be, oh yeah, I'm gonna do this. So these SMART objectives allow that to sort of be focused, because a New Year's resolution, as many people do when they join a gym as well in the new year, then they stop going over time. So they lose the enthusiasm. But this offers that opportunity really to make sure that these are focused as they can be, and directed in the right way. So specific, it's the what, the why, the where, the who, basically. It needs to be a specific target, a specific strategy. Measurable is very important, because what we need to be able to do afterwards is evaluate whether we've achieved these objectives. So it might be that we want to achieve 50% gross profit margin. There you go, I've got some figures in for you. It might be that we want to grow our customer base by 5% next year or something like that. But if we put some measurable elements into it, then it allows us to evaluate, have we achieved it, have we exceeded it, did we not quite get there, and adjust things accordingly. The achievable aspect, yes, it's got to be achievable, but it's got to be the right balance again. I'm coming back to keep going on about balance and things. It's got to be challenging enough to drive us, to motivate us, to push us, but it shouldn't be unachievable. The risk is that then demotivates us, because we set a target that we're never ever going to get there. Especially if this is being passed down to team members and that we're holding other people accountable as part of this. We don't want to be demotivating people. We don't want to be setting employees ridiculous targets that they're never ever going to achieve. It's just not going to work. It's not going to be successful. Relevant, it sort of, as it suggests, it's got to be relevant to the overall aims and aspirations of the business. Where do we want to get to on that journey again? What's the destination? Is it relevant? It may be relevant, but you've got to look at the long-term plan. A director who's wearing all those different hats, as Katie had earlier in her slides, they might be the HR person, they might be the marketing person, they might be the operations director, they'll be the internal accountant. They're doing all these different things as well as sort of trying to push the business forward. Is it relevant for them to be wearing all those different hats rather than being focused on, if they're really good at doing sales and getting more business through the door and then delegating some responsibility, that's probably more relevant than them wearing all these different hats and trying to do things. They might be able to do all these different tasks, but it's not as relevant as pushing the business forward and delegating some of the responsibility to other people. So just being focused on that. And timely is quite straightforward, really. We've got to put a time limit, we've got to time bar some of these targets, because if we don't, we're never going to get there. The measurable bit, the timely bit, hand in hand. How are we going to hit that sort of turnover at that point in time? How are we going to get this amount of additional customers by that point in time? Because if it's not timely, we'll just kick the can down the road and just say, well, yeah, I'll do that next year or whatever. Key thing on this is that I'm not asking you to write it all down and then live by it. It's not necessarily a Bible. There's a plan A, there's a plan B, we've crossed it out, we're on to plan C at the minute. Things happen. Past 2 years, Katie said that we're not allowed to mention the COVID word, but the past 2 years has thrown a lot of businesses off course. They might have a business plan, they might have had a business plan that they wrote 10 years ago, 20 years ago, even 5 years ago. COVID has impacted a lot of businesses in a lot of different ways. We might not be where we wanted to be right now, but we're recovering. So this is there to really say that we are allowed to change things. We don't have to do everything by the book that we've just written. We can change where we're going. Right, I am going to talk about something financial. So just to touch upon this, this really is a subject in itself, and I can talk at length on this. But cash flow and projections and financial forecasting and things like that is really important, and it sort of goes hand in hand with the business planning aspect. Identifying the cash flow gap really, it's relevant for all businesses. Maybe more relevant to new businesses that are setting up and thinking, well, where am I going to get finance from to be able to do these sort of things? An expanding business that's suddenly going to sort of double their and scale their business. They will need to identify this cash flow gap, but equally for continuing businesses as well. There's been huge high profile corporate collapses because of or put down to cash flow issues. So this is just a really, really basic summary of a cash flow gap. So you receive goods here at the start of this timeline here. The supplier payment might be due 30 days down the line. It might take us 30 days to work on that before we actually are able to pass that out to our customer, and then they might take 60 days. That might actually be good. Might be further down here. Customers can then take any time to really pay their invoice. The supplier payment's due here though. We've then got various other things that need to be brought into the mix. So we might be paying employees on a weekly basis. So actually our employees are being paid in all these gaps in the middle as well. We may have loans that we're paying back. Bounce back loans, for example, all the COVID loans and things. But we've got this gap between the supplier being paid and our payment coming in. That's a massive, massive gap there, and we've got to make sure that we're plugging it. and that's really relevant from a cash flow perspective, and that's the importance of it really, just to see when are things going to be paid, have we got sufficient working capital and finance in place to cover that gap. So why cash flow? We can do short-term cash flows, we can do long-term cash flows. The short-term cash flow might just cover you for the next 13 weeks, just so that we can see on a fairly accurate basis. We know what orders we've got in, we know what we need to do, we know the employees that we've got in place. So it gives us a really good, accurate reflection of where we need to be, or projection about where we need to go. With a more longer-term cash flow, it's a little bit hypothetical to a degree. We can't guarantee that we know that all these sales are going to come in over the next couple of years if we're looking at something like that. But it gives us a good indication based on historical performance and things that have happened more recently about where we maybe need to be going. If we're planning then to maybe bring in a new piece of equipment or launch a new product, for example, again, a long-term cash flow forecast can sort of model the impact that might have on our business, the additional resource that we might need to commit to it, all that sort of stuff. The opportunity to improve credit control, I mean, it's quite evident from here that actually if we could narrow that gap, I mean, that customer payment might end up coming here because they might say, oh yeah, I'm not paying it until this date, and you can put whatever terms you like on your customer terms, but they'll pay it when they want to pay it. So that might be here. We might need to sort of narrow that gap. So that cash flow then allows us to sort of plan, well, actually, if we can improve credit control, if we bring a credit controller in, if we chase our debts in a slightly different way and manage that rather than just waiting for it to come in. People don't like to challenge that, do they? Yeah, focus on bringing that in. Problem spotting. Do we need more staff? Do we need fewer staff? If that cash flow projection actually shows that actually there's been a bit of a downturn in the market, can we afford to keep all of our employees, all that sort of stuff? It could highlight some of that problem that we might have. Might be a good problem, might be a bad problem. Analysing and evaluating costs, particularly important at the moment with inflation being as it is. We need to monitor our costs, and it then sort of moves on to assist with pricing, because some of those costs we're going to have to absorb. We can't sort of suddenly cut off all of our product supplies going up. We can't negotiate better prices. To an extent, we've got to live with it, but we might need to reflect that therefore then in our pricing ourselves, just so that we can manage that margin, make sure that we can pay the staff, etc., etc. We touched upon it earlier about considering the future plans with scenarios, so new products being launched or new equipment being purchased, that sort of stuff. So again, a cash flow can sort of show us what that looks like from a numerical point of view. Planning for cash flow gaps, which we touched upon. From a positive aspect, we might end up with quite a lot of cash sat on the balance sheet, and it might also be from a positive angle. How are we managing that surplus cash? It might be that we actually want to model in our cash flow projections that we're paying a special dividend out to the shareholders. It may be that we want to invest that in new plant and equipment. It might be that we just want to invest it better to get a better rate of return on it. The cash flow projection also then gives us that opportunity then to look back, and this is again another misconception with accountants, that the accountant is always looking backwards. Yes, there's a compliance angle to everything that we do. We have to get the accounts done for last year and file those with Companies House and calculate the tax and get that across to the revenue. But a lot of what we're doing here with the cash flow side of things in particular is looking forward with the business planning. We're looking forward. Being able to then use that tool, use that cash flow and look backwards when we come to do the annual accounts. So, right, how far off were we? What changed? What didn't happen? What did happen? What worked well? What didn't work well? We can then evaluate that. We can look at the actual performance against that expectation. And overall, it's just going to assist us in meeting our aims and objectives. It's particularly useful, as I say, in scenario planning and developing circumstances. So COVID was a prime example of it, and particularly now, as I say, inflation's having a major impact on things. I went and filled the car up earlier on, not to scare everybody, but it was 190. I've rounded up. I'm not doing the 189.9. It was 190 for the diesel this morning at Tesco as well. So yeah, that sort of rising cost of living, the impact of inflation on businesses is particularly scary, and being able to monitor that is going to be useful. So what to do now, and how can we help? Obviously, I would be saying exactly the same as Wilkin Chapman. Speak to us, pick up the phone. My email's on the slide. You've all got a copy of it there if you want to talk to us. But quite clearly, looking at a business plan, looking at the objectives, setting some objectives, but then equally with this sort of work as well, speaking to us, getting these things in place about sort of making sure that we're in the right place to move forward. Maybe it's expansion, maybe it's just making sure that our businesses are efficient, protecting jobs, all that sort of stuff. There's loads of different reasons for it. But that sort of specialist work as well, at the moment, there can be grants out there potentially for these sort of things. So if we're pushing forward with the business plan, because we've never had one, and it sort of goes hand in hand with producing some cash flow forecasts and things like that, engaging with a professional advisor, whether it's somebody else, there could potentially be grants out there at the moment. And Josie Stewart's here at the front. Give us a wave, Josie. So Josie's dealing with those sort of applications at the moment, businesses. So Josie's working with the council and doing grant applications for that sort of specialist work, the non-routine work, to really push businesses forward in that respect. It's the RDF funding. It's going to dry up in June next year. So again, getting these things in place, getting this ball rolling is really key. So Josie will be around to be able to speak to, and we can share her details later on as well, Josie. That's all right.
Yeah, unfortunately I won't be around because I've got a meeting to go to. But yeah, if you do want my details about what grants are available out there, then definitely here to help.
So that's me. Thank you very much.
Well, so firstly, morning. Thank you everyone for coming once again. I pulled the short straw. I've got the graveyard shift, or I'd like to think as Liz Johnson, our business development, I'm the cherry on the top. So I'll let you put that in the feedback forms anyway. Just to introduce myself, my name's Adam Motley. I'm partner in the corporate commercial team. So my job's split. I do corporate matters, which is buying and selling businesses, mergers, acquisitions, restructures, that type of thing. It's not that I'm going to be focusing on today though, it's the commercial element. So that's your contracts, your day-to-day terms and conditions, the things, the contracts, the agreements that allow a business to tick. So I'll be covering kind of three elements on my slides, and you'll be pleased that I got the timing slightly wrong. So mine's shorter than Katie and Paul's as well, so you can thank me for that at the end. The first is just reviewing some contract myths that we come across, just to dispel them really, give a bit of information on those. I'm then going to look at the dangers of not having contract terms, and then finally an overview of just some contract red flags. So we get a contract through from a client and they'll say, can you just red flag review this? And it'll just give you some high level points that we would look at initially to say, right, these are the bits that we just need to make sure are okay to begin with. So I'm going to try and make it a little bit interactive as well. So with the contract myths, Katie's stolen my thunder a little bit on the first one, so maybe our communication needs to be a bit better. But so we quite often come across people say, well, there's nothing in writing, so there's no contract. So on a show of hands, who thinks that's right? No one. Who thinks that's wrong? Yeah, so Katie didn't steal my thunder. No, so yeah, that's incorrect. Certain things do need to be in writing, like your restrictive covenants, that type of thing. But you can have a verbal contract. You can have a contract that's part verbal, part in writing. Obviously, if you're looking at verbal contracts, things that are a mixture of the two, not in black and white, then at that point in time, it's a bit difficult to prove what the terms are. So obviously, our advice would be, always put things in writing. Secondly, in a similar vein, contracts always have to be signed to be enforceable. I think we've already covered that slightly. Yes, in certain situations, like the restrictive covenants that Katie spoke about, in certain instances, the law says that yes, contracts need to be signed. But that's not the case all the time, certainly. And thirdly, and this is a little bit more specific, a bit more technical, you can include a penalty in the contract if the other person breaches the contract. So probably an example here would be best. So if I agree to sell 100 widgets to a customer, and if those widgets don't arrive, that customer's machine would be out of action, and it's costing them £500 a day in production. That's their loss. So that customer couldn't put in the contract with me as the supplier that for every day that isn't producing, I'm penalised by having to pay them £1,000. They can only recover the loss that they suffer. They can't put a penalty on me. So hopefully that makes sense. But obviously we can ask some questions at the end if you want. So this is one we come across quite a lot. So I send my terms and conditions out my invoice, so that means they apply to the contract. So again, on a show of hands, who thinks that's right? Who thinks that's wrong? Some people aren't sure. So you need to be sending out your terms and conditions at the point when the contract comes into being. That's when one party, the supplier, says, I'll sell you the 100 widgets for £500. The other party then accepts that, and that's the point when the contract forms. That's the point when your terms and conditions need to be out with your customers, because otherwise you're too late. The law will imply certain terms, as I'll come on to, but if you want your terms and conditions to apply, if you spent your money with a solicitor like me, getting them written up, etc., you need to make sure your process works as well. And then, I think our marketing team have reordered these. Sorry, so I'm going with the third one now. But it was on my. Sorry, you've got a question.
Yeah, when you send out an invoice, a friend of mine did the same because they weren't paying. They were saying 60 days, and his was 7 days. He put it on the back of the invoice, which they signed. They had to pay immediately. So
say that again. Sorry.
he put it on the back of his invoice that they had to pay within 3 days.
Yeah.
Because they've been stupid.
Yeah.
And because they signed the invoice, they have to pay that.
Yeah, was he being paid up front for the work, or was he?
No, on delivery of service.
Yeah, so I mean, it's a question of degree, because if you're sending out the invoice at the end and you send the terms and conditions and the person doesn't challenge it, then you might get away with it. But when the contract forms at the start, that's really when you're setting out your stall and you're setting out your terms and conditions and the conditions that apply.
I think it was the same terms. They just weren't. They're a massive company. They're just ignoring it. So you've signed it on the back of the invoice.
Yeah. Yeah. And I mean, it's one of those, and it's something Paul said. You can't eliminate risk that you're going to get a big company that just goes, well, I don't care that it's your terms and conditions. Sorry, we're going to pay how we want to pay. But at least you're trying to mitigate that risk as much as you can. So if you're in that situation and you do need to take action against them, you're starting from a position of strength rather than having to try and work out what your payment terms are later down the line. So yeah, sorry, I'm going to go to the third one because that's the order of my notes. So as solicitors, whilst we've got a reputation for obviously putting everything in small print and tying people in knots, it is getting harder and harder to be able to do things like that. And like when you're sending out your quotations and things, you really need to be sending your terms and conditions with your quotations ideally. There's more and more case law coming out that actually if you just reference your terms and conditions on your quotation, that's probably not enough, especially if you've got some not so nice terms into things like indemnities, caps on liabilities, which I'll touch on in shortly. But if you've got those in there, you really need to be highlighting those to your customers before you send it, when you send the terms and conditions, when you send your quotation. And the final thing, final things looking at is if you receive your supplier's standard terms of business, you can't challenge them. We've had that where people have said, well, I've had their standard terms, so there's nothing I can do. That's not the case. Commercially, you've got a decision to make as to whether it's worthwhile challenging them. You know, do you need those goods and services right now? If you do, then maybe it's not worthwhile because you will spend a bit of time going back and forth negotiating on the terms. So it's a commercial decision, but it's never the case that, you know, you just have to stick with what they've offered you. So moving on from contract myths, I'm just going to look at some of the things that if there are no contract terms agreed and the dangers of those and what the law will imply. So we all know that solicitors tend to have a worst case scenario, pessimistic look on things, and you know we want everything in writing, we want it all tied down in black and white, and sometimes that's just not the case. So hopefully, even if you can't agree some terms and conditions and you are going on a kind of verbal agreement, you maybe will understand a bit better what's implied. So the first is in terms of the standard to which you have to supply the goods and services. If you have nothing in your contract, then these acts will imply that the goods services have to be of satisfactory quality and they have to be fit for purpose. The problem with that is that's quite subjective. What's satisfactory quality to me will be different to you, what's fit for purpose. So what we would always try and do is in the contract make things objective, make it so that it's in black and white, there's a specification, you know, you will provide goods that meet the specification, as opposed to, you know, you can see satisfactory quality, fit for purpose, it's difficult to know what that means. Second and third points there, if there's no time for delivery, it's a reasonable time period that's implied. So if you need something by a certain date, you need to get that stated in the contract between you and your supplier, or if your customer is telling you they need something by a certain date, you need to work with them to try and agree whether that's going to be a contract term, because otherwise it's reasonable time, and that may leave you with a bit of difficulty if something is late. Payment terms, you might be expecting to be paid on milestones, you might be expecting a deposit. If you don't agree those terms and it's not clear, the law implies that it's payment on delivery of goods and services. So that's right at the end once you've finished, or you've finished your services, provided your goods. And then some businesses here will be dealing with consumers in business to B2C contracts. Consumer Rights Act and other areas of the law will imply a lot more terms into those kind of situations. So if you are dealing with consumers, we really would strongly recommend that you get some terms and conditions drafted, that you've had those looked at, and you know you understand the pitfalls, because consumers have a lot more protection than if you're dealing with a business to business scenario. Moving on, another danger is potentially unlimited liability. So if something goes wrong, it's not quite as simple as that. There are some caveats to this, but on the face of it, you could have no monetary cap to the supplier's liability. So if you as Katie said, things go wrong in business. If you provide goods and services that are defective, etc., then you can be more at risk. What you can do is, if you've got standard terms and conditions, is you can mitigate that by putting a cap on your liability. So you know when you're into the contract, if things go wrong, you know what the monetary value of your risk is. And then also things like loss of profit, loss of business, those type of things can be excluded. So we can exclude those. So if you've got, for instance, you're selling, again, 100 widgets, and those widgets are needed for an onward sale for your customer. If your customer's told you that contract's worth £50,000 to them, and you're aware of that at the point when you're delivering these widgets, and you've agreed to provide them by a certain date, or to a certain standard, you provide them late, you provide them when they're defective, and that has an onward effect to that other contract. If you don't exclude loss of profit as recoverable from your customer, potentially you could be liable for the knock-on effects of that subsequent contract. So it's quite important to do that. As you can see, if you're the supplier, you want to be limiting your liability as far as possible. And finally, on the danger of no contract terms, it is ambiguity. If we're in a situation where we're having to get our litigation team involved, if you've got something in black and white, something to turn to, something to point to, it's much easier sat in front of, as you mentioned, about someone at a tribunal, a judge. You know, rather than saying to them, well, here's a witness statement, this is what I thought the terms were, the other side have put a witness statement in saying, well, this is what I thought the terms were, and then they've got to make a decision between. If you can sit and say, well, it says here, you know, that the loss of profit is excluded, you probably don't ever get to court, because you can start from a position of strength, and you can hopefully sort out disputes cheaper, quicker, more effectively. So final area is contract red flags, and so what we would kind of look at, covered some of these a little bit. We would always look for the standard to which you're going to be supplying. If you're the supplier, the standard to which you're going to be supplying your goods and services. If you're the customer, you want that to be as high as possible. If you're the supplier, you know, you want to try and make it as specific and objective as to what you're going to supply, so that it's very clear, it's very easy to define, and when you've done that, to show you fulfil your obligations. Said things go wrong, so what's the remedy if you provide defective goods and services? If you're the supplier, we always try and limit that to just repair, replace, or reperform, and we would exclude any ability to recover damages. And that means that to mitigate your costs if things go wrong, it will cost you a lot less to just, you know, get some new goods out to someone or to reperform the services than it would do, as I said, to have those knock-on potential liabilities as to their loss of business, loss of trade, all of those type of things. Liability, again, touched on it slightly, but as a supplier, you want to be capping your liability, excluding certain losses, those type of things. Conversely, if you're the customer, you want to be reviewing those contracts and seeing, has the supplier capped their liability at the price that we're paying them? In which case, if things go wrong, you're not going to get an awful lot of recovery. You've not got an awful lot of coverage, and so you take the risk on. Indemnities, it's a bit of a technical point in terms of contract drafting, but if there's indemnities in there, indemnities gives the highest level of protection. If you are the supplier, if you're a customer and you get your supplier to indemnify you in the event of a breach, you can recover a higher level of damages and your losses if you've got that in there. So if you're a supplier, if you see that you're indemnifying your customer for anything, I'll be putting a big red pen through it and saying to you, you know, you really need to consider whether you're willing to give this. And then finally, delivery obligations. If you're the supplier, you want things to be, you want as much flexibility as possible. Delivery dates need to be estimated. You need to be giving yourself reasonable endeavours to meet those dates. If you're a customer, you want to be tying it down and saying, no, you will supply these on this date, and it will be, you know, they will be with us, and making it as clear as possible in those circumstances. Payment terms. If you're Paul's touched on cash flow, you can mitigate your cash flow issues by trying to get people to pay up front, trying to get milestone payments so that as you achieve your contract milestones, you're able to invoice as you go along, rather than leaving things right to the end. But you need to make sure that those terms are clear in the contract. And finally, price changes. This is something that we're coming across more and more and more, especially in long-term contracts. We'll often get asked to review a 2-3 year contract. Historically, you'd have seen kind of a yearly annual price review. You're now looking at, in certain sectors, so like the food production sector, those type of things, it's monthly review of prices, because things are so volatile at the moment. So if you think you're entering into, if you're a customer, if you think you're entering into a fixed price contract, you need to be looking in the actual contract itself, see if there's any triggers for the supplier to be able to review their terms on a yearly basis, quarterly basis, all those type of things. So hopefully that's given you a bit of an oversight of what we do as a commercial team. It's dispelled some contract myths, given some food for thought on contract terms, and as Katie and Paula said, you know, we're happy to have a chat. We're going to have a bit of a Q&A now anyway, if anyone's got any questions. But if anyone's got any specific question on contract terms, you know, whether that's supply or customer, then I'm happy to have a chat either now or afterwards. So thank you very much.